Hello and welcome to BYJU'S Exam Prep IAS. My name is Harshmeet Singh and I welcome you all to today's explained session. The topic for today's session is the POSH Act of 2013. That is the Prevention of Sexual Harassment Act that was passed in the year 2013. In this session, we will be discussing about the background of the act, why was this act required to come into being, what is the history of sexual assault laws in India, and why exactly is the law in the news right now? Why exactly is the need for us to discuss this law right now with you in this session? All of that will be covered in today's explained session. Now, to begin the session, it's prudent to quote Dr. B.R. Ambedkar, the father of India's constitution, who rightly said that I measure the progress of a community by the degree of progress that women have achieved. Now, in the past few years, we have seen that there has been a drastic improvement in the situation of women in the country. And this is a laudable fact for everyone. However, the situation was not the same even if you go back a couple of decades or 3 or 4 decades. Let me start today's session with a story that is not really a happy story, a story that is not something that I'm proud to share, but it is important for us to share this so that we understand why was it a requirement for this law to come into being. We go back to the year of 1992. There is a lady in Rajasthan called Bhanwari Devi. Now, Bhanwari Devi works for Rajasthan's government. She works mainly in the Women's Development Program. Her job is very similar to the job of ASHA workers right now. She is called a Sathin. The part of her job is that she needs to spread awareness in the community about topics such as hygiene, family planning, necessity of educating girls, etc. So all in all, a job that is essential for the development of a community. As a part of her job in 1992, she saw that in Rajasthan, there was a 9-month-old girl child who was being married. And I am not being mistaken, it's a 9-month-old child that we are talking about. As a part of her job, what did she do? She tried to stop that marriage. It was just a part of her job because that is what she was supposed to do as a representative of Women's Development Program. What did she get in return? She was gang raped by 5 people in her village for attempting to stop that child marriage. This is what Bhanwari Devi got. What did she do next? She obviously approached the police. She, with her husband, they approached the trial court. And as it happens with many of these cases, especially in the villages in India, there was no attempt made by the authorities to gather evidence. Her physical checkup was done after 52 hours, which should have been done in the first 24 hours. And as a result, in the first stage at the trial court, no person was accused. In fact, as I'm talking to you today, even today, no person has been punished in the Bhanwari Devi case. However, the story did not end here. After this incident, a lot of women-related organizations, especially in Rajasthan and in other parts of the country, including in Delhi, came together. And they said that we will fight for Bhanwari Devi on her behalf. We will go to the court and we will ask for justice. There were multiple organizations that came together. One of the organizations, and I'm sure that as a UPSC aspirant, you will be familiar with that name. One of the organization was called Vishakha and Women's Rehabilitation Group from Rajasthan. Now, if this seems familiar to you, this is because of something called the Vishakha Guidelines. 1997 was a landmark year in which the Supreme Court of India gave something called the Vishakha Guidelines. Now, Vishakha Guidelines was actually a result of this attempt by these women groups who were fighting on behalf of Bhanwari Devi. There were multiple groups who came together. They filed a writ petition in the Supreme Court, and the Supreme Court said that even though we do have certain laws in India that try to punish people who are harassing women or who are sexually assaulting women, but they are not enough. They are especially not enough because they don't cover women and the assault that happens at their workplace. We have to understand what Bhanwari Devi was doing was she was performing her duty. So what happened with her was at her workplace. And that is why the Supreme Court of India said that we don't have enough stringent laws right now in the IPC. And that is why we require certain laws to be made to protect women at their workplace specifically. There have been so many incidents of sexual harassment of women at workplace even before the Bhanwari Devi case as well. But this was a time that all these women organizations came together and they went to the court. Now, when they went to the Supreme Court in 1997, the Supreme Court gave a set of guidelines which are now famously called as the Vishakha Guidelines. Now, just a clarification here. This is called the Vishakha Guidelines or the Vishakha Guideline case, not because it was only the Vishakha group or the Vishakha NGO that was at the forefront of it, just that when the case was filed or when the writ petition was filed in the court, the first applicant's name was Vishakha and Women's Habilitation Group. So it's not to say that the other groups did not work equally hard, the other groups also worked equally hard. In fact, there were many activists, many lawyers that worked on behalf of Bhanwari Devi. So the Vishakha Court judgment came up in 1997 in which the Supreme Court of India gave a set of guidelines about what exactly should every workplace make sure for ensuring the safety of women. For example, the Supreme Court said that at every workplace there should be a committee where women working in that workplace can go and complain if they have any issue. The committee must take stringent action within a certain time limit. And there were many other such guidelines that were given by the Supreme Court of India. That was back in 1997. About 20 years later, I'm just rounding it off, but about 20 years later in 2013, the Parliament of India finally passed a specific law to turn those guidelines into stringent laws on the ground. And that is the law that you today call the POSH Act of 2013. This is Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act of 2013. This is a topic of discussion that we have for today. Now, the Vishakha Guidelines that the Supreme Court gave, Supreme Court was very particular about these guidelines. The Supreme Court said that the Vishakha Guidelines are required because any sexual assault on women, especially at their workplace, is a gross violation of the fundamental rights given to them under Article 14, Article 19 and Article 21. In fact, the Vishakha Guideline case is regarded as one of the best examples of judicial activism in the country. As you understand, judicial activism means an act of the court or act of the higher judiciary to go beyond their duty and make laws or guidelines themselves. Because if you understand this clearly, making guidelines or making laws is a part of the legislative's job. It is the executive that makes the guidelines. It is the legislative that makes the law. The judiciary has to just adjudicate on those laws. But this was a time when the judiciary took a step ahead and said, no, because the legislative or the executive are not doing enough, we will be the one who will make these guidelines, and that is how the Vishakha Guidelines came into being. To the government's credit at that point of time, the government also, that was represented by the Solicitor General, also agreed and said, yes, we will work towards ensuring that these guidelines are translated on the ground, and we will also try and make efforts to ensure that these guidelines convert into concrete laws, and that is how, in the time later, we saw that the POSH Act came into being. Now, let me discuss with you some important pointers of the Vishakha Guidelines. What did the Supreme Court say exactly? The first major problem before the Vishakha case was that there was no clear definition of sexual harassment. Now, the problem here is, let's say that I am interacting with a human being, let's say a girl or a lady. For me, I may touch her shoulder, for me it might be casual, for me it might be okay, but what if she is not okay with it? What if the lady who is interacting with me is uncomfortable? That is when we have to understand that the definition of sexual assault is not just physically assaulting a woman. It can even be an inappropriate touch. It can even be bad language being used with a woman. It can also be a verbal banter that may make the women uncomfortable. The laws or the guidelines before Vishakha Guideline did not really have any detail about what is sexual assault or what is sexual harassment. And that is why there were many cases where women who were harassed at their workplace, they used to go to police station, tell the police person or tell the officer that something wrong has happened with me in the workplace, and the police used to ask, tell us what happened. and the woman would say, someone touched my shoulder, someone touched my back, and the police officer used to laugh. Oh, this is nothing, go away. This is nothing, this is not assault, this is not harassment. Because there was no proper definition of this term sexual harassment. That is why many of these cases were not even recorded or not even reported earlier. So Supreme Court said that sexual harassment has to be defined clearly, and sexual harassment can be any physical touch or conduct, any unpleasant taunt, misbehavior, showing pornography, or asking for any kind of sexual favors. In fact, after the Vishakha Guidelines, the definition of sexual assault or sexual harassment has been expanded even further, and I will discuss with you some of the pointers that have been added by the Union government of late. The Supreme Court also said that sexual harassment at workplace should be informed, produced, and circulated. Means people who are working at the workplace should be informed what exactly is sexual harassment, so that people later on can't say, oh, I did not even know this is sexual harassment, or I was not allowed to do this, I was just being friendly. No. It is the responsibility of the employer to ensure that this kind of information is circulated, and everyone at the workplace is aware of what are the rules and what are the guidelines that they need to follow. Next, there should be a time-bound redressal of complaints. Even in the law that we have, the POSH guidelines, there is a time boundation within which the Internal Complaints Committee has to investigate the matter, within which this matter has to be completed and it has to be concluded. That is what the Supreme Court also said, because in most of these cases, while it takes immense courage on the part of the women to even go and file a complaint, even when the women do file a complaint, the matter goes on so long, and in that time period, they most probably lose their job also. They are not seen well in the society, and it is the women or the person who was actually harassed, they are the ones who suffer the most. So it has to be a time-bound method. Then the Supreme Court also said, as a part of the Vishakha Guidelines, that there should be a complaints committee, and most importantly, it should be headed by a woman. Also, more than half of its members should be women. Again, the intention is that it should be comfortable for the women or the women employee to go ahead and file these cases. Because as a woman, you would not be very comfortable sharing it with a male or with a male officer. And that is why such a committee has to be headed by a woman. Not just this, there has to be involvement of NGOs also, so that there is not internal pressure put on the female employees. These were main pointers or the main provisions of the Vishakha Guidelines that the Supreme Court had given as a part of the 1997 judgment. Now, the question also arises, did we not have any law before the POSH Act of 2013? Means, were the women not even protected at their workplace in India in 2012 or 2011? That can't be true. There has to be some law, right? So the reality is that before POSH came into being in 2013, yes, there was still punishment for sexual harassment of women. There was punishment under two sections of the IPC, that is section 354 and section 509. These were the two sections of the IPC that were specifically made to address sexual harassment of women at the workplace. But there were some problems with that. First problem, as per these acts, there was no provision of a complaint committee. As per these provisions, if a woman is sexually harassed at the workplace, the expectation is that the women would have to go to the police station and they would conduct the inquiry and see if someone is guilty or not. Now, unfortunately, the police station is not really the most inviting place for anyone to go, let alone for a woman who has been sexually harassed. And that is why you would see that in most of these cases, the person who was harassed did not even go and register a complaint. That is why we did not really see a lot of convictions under this particular section of the IPC that was already present. Secondly, as I said earlier, these sections also did not really give a proper definition of what constitutes a sexual harassment case. Again, for me, I may be just being overtly friendly, I may touch a person on the shoulder, but for the other person, this might be extremely uncomfortable. For me, inviting a female employee to overnight parties, say that no, this is a socializing that you have to do that, or asking a female employee to go to office trips for 2-3 days very, very frequently, for me that can be fine, but for a female employee that may constitute as harassment. All these details were never given in this IPC section, which now is a part of the law. That is why in the pre-2013 era, there was a lack of provisions that we had, and that is why the women did not really feel safe at the workplace. So the presence of IPC section 354 and 509 did ensure that at least we do have certain punishment, but it was not really the best kind of a law that we could have. Many people, in fact many women activists also said that these two sections of the IPC were very badly worded. Why? They said that outraging the modesty of a woman. Now, outraging the modesty of a woman is not a phrase that many activists or women really appreciate, and that is for good enough reasons. Outraging the modesty of a woman means that anyone or any male has so much power in their hand that they can go ahead and disrupt the modesty of a woman. This kind of a phrase is making the person who is being harassed suffer even more. And that is why there was a requirement for this kind of a phrase or these kind of sections to be changed. And that is when we finally had the POSH Act of 2013. Now, just to give you a slight more detail, this law also took a lot of time to actually come into being because the process started in 2010. The first time that the bill was introduced in the Lok Sabha was in 2010, and after multiple revisions, finally, it was in 2013 that it was finally passed. Now, what are the main provisions of this act? The good part about the act is that it is much wider as compared to the Vishakha Guidelines. While the Supreme Court gave just a framework, a brief lining of how the government should work, of how the workplaces should interact, but the law is much more stricter and it is much more wider and tells what is the responsibility of the employer towards their employees. The law says that aggrieved women can be a range of women irrespective of their age, employment status, while the workplace includes corporate, private places, and even in the unorganized sector. This one single sentence actually contains a lot of details that you need to understand. Number one, earlier in many of these cases, when a woman used to say that I have been sexually assaulted, and it is so unfortunate that many authorities or people who are at powerful position used to say, oh, no, you are so old, how can you be sexually harassed? This is a fact that used to happen earlier. That is why there was a requirement that the law must say that women of all the age groups are covered, women of all the employment status are covered. Because at least the women who are at a higher position in the society or who are at a higher position at the place of employment, they still might have a voice that is heard. But what about women who are working at the lower level? What about women who are not a prominent face in their workplace? Do they have a voice? Not really, if you actually think about it. And that is why the law says that it does not discriminate on the basis of age, on the basis of employment status, and also very importantly, it also covers the unorganized sector. Now, what can be an unorganized sector? Let's assume that you live in a colony, outside your colony or just nearby your colony, there is a ration shop. Or maybe there is a salon where you go to for a haircut or something like that. In that ration shop or in that salon or in your beauty parlor, you might see that there are some female employees who are working. Now, that is not an organized sector, that's an unorganized sector because they won't be paying PF, the Provident Fund would not be deducted, they don't have the employment benefits that they would require, and because they are not in the organized sector, they are somewhere not really registered with the government portals. But this law covers them as well. So people who are working in the unorganized sector are also covered under this law. Then, very importantly, specific time limits have been set up for the inquiry and for the redressal of the complaints also. And we'll discuss that, what is that time limit. Now, how does the Act work? The Act says any establishment, that means any company, which has 10 or more employees. So any company having 10 or more employees, for them it is mandatory that they should have something called ICC, called Internal Complaint Committee. This is a mandatory requirement for organizations having 10 or more people. Now, what will this committee do? First, this committee will be presided over by a senior female employee. Now, the number of members of the committee are not mentioned, but it should first have senior female employee. Secondly, it should have an external member. Now, what is an external member? External member usually can be someone who is from a local NGO, someone who is respected in the society at the local level, someone who has information about women issues, etc., or who has been a women rights activist. And there can be 2 other members. This is what the internal complaints committee will be. Now, the first question that should come to your mind is, but what happens to those organizations which don't have 10 members? There may be some small scale organizations that don't have 10 employees. On the other hand, there may also be the case that there are many organizations who have very few full-time employees, but a lot of other people who work for them on part-time basis, on contractual basis, but their full-time employees are very few. What about them? For them, there is another provision called the Local Complaints Committee. So what happens is, outside the organizations at the district level also, there has to be a committee called the Local Complaints Committee, specifically to receive complaints from those organizations where the Internal Complaints Committee has not been formed because they don't have 10 members. So if there's a small office which only has 5 or 6 people working, if there's a women employee in that organization, she has to register a complaint. Where will she go? She will go to the Local Complaints Committee. That is mainly because, number one, it might be for those organizations which have less than 10 members, or there is one more instance. Let's assume the women has a complaint against the owner of that organization itself. Now, we are not living in an ideal world, so you should understand that if a woman has a complaint against the owner of the organization or the CEO of the organization or the chairman, there is a very little chance that the women might get justice within the company. At the end of the day, the people in the internal complaint committee will be employees of that person only. So how will they take any complaint against him? That is why if the complaint is against the employer himself, for that also the women can go to the Local Complaints Committee, because they are afraid that in the internal complaints committee they might not be able to get justice. This Local Complaint Committee has been given the same power as a civil court under the Civil Procedure Code. What does that mean? As the civil court, they can also summon people, they can ask people to come and be a witness, they can admit evidence, they can investigate the matter. That is what they can also do. Now, let's assume they conduct their investigation. Now, what happens after that? Now, if it is found that there was a case of sexual harassment, then the committee will submit the report to the police station, and then the police will take up the inquiry to see what kind of punishment is to be given. First. Secondly, the committee will also recommend that internally how the female employee has to be compensated. How is that? Under this law, every company has to make guidelines that if someone is found guilty of sexual harassment, that person will be punished by maybe a cut in the salary, maybe suspension, maybe termination, etc. So there will be internal action also that has to be taken by that organization. It is their responsibility. And if there is a case of sexual harassment, this report will go to police also, and then the police will conduct their own inquiry and the matter will go to the court and action will be taken, or whatever the punishment is that has to be given. The report that is concluded will be given to both the parties. So both the parties will have the report, and whatever they want, if they want, they can appeal in the court also. Now, we will discuss about the appealing in the court part and the other provisions also. Before that, as I said earlier, one of the problems with sexual harassment that used to exist earlier, even today also, is that there is no proper definition of what is sexual assault. So now let me share with you certain provisions of what exactly constitutes a sexual assault or a sexual harassment in this case. Now, sexual harassment includes, number one, asking for sex in exchange for a benefit, using degrading words or comments, using degrading pictures or objects, calling people sex-specific derogatory names, repeatedly asking for dates, not taking no for an answer, making sexual jokes, bragging about sexual prowess, etc. It's a long list of provisions. All of these constitute sexual harassment. This is why this law was required, because before this law there were no details about what is sexual harassment, and that is why it did not give enough confidence earlier to the female employees to go ahead and file a complaint against the person. Now, what exactly is the procedure to file the complaint? Over here, there are certain issues with the law, certain intricate details that you must understand. We discussed this in the class also, that every single word well written in the law has specific meaning. For example, the word may and the word shall are very different from each other when they are used in a law or when they are used in the Constitution of India. The word may means that it is voluntary. This action is voluntary. The word shall means that this action is compulsory. So the law says that the female or the women who has been harassed may file a complaint. So number one, it is not compulsory on the female to go ahead and file a complaint. But if the female does go and file a complaint, then the internal complaint committee shall render all the assistance. So it is compulsory for the committee to assist, it is compulsory for the committee to take up that complaint, investigate that matter, but it is not compulsory on the female employee at the first place to file a complaint, number one. Second, under the Act, the complaint has to be made within 3 months of the date of the incident. Within 3 months. One exception is if the internal complaint committee agree that during these 3 months she was not really in a situation physically or mentally to share this trauma, then they might give her an extension. But usually if you don't want an extension or if you don't want to depend on the complaint committee, then as a female employee you have to register that complaint within 3 months of the incident. Otherwise you can ask for an extension from the internal complaint committee. Now what does the ICC do? What does the internal complaint committee do? If they think that they are not empowered enough or they don't have the resources or the knowledge to investigate the matter. Because see, at the end of the day, what is the internal complaints committee? They would have a senior female employee, they might have an NGO worker, they might have 2 other members, none of them are police, none of them are CBI, they might have watched a lot of CID on the TV, but they don't know how to investigate matters, right? So if they don't know how to investigate the matters, they always have an option that they can just pass on that complaint to the police. So ICC will pass on the complaint to the police, or if they think that they themselves know how to do this, they can then first start an inquiry which has to be again completed within 90 days. So within 3 months of the incident, the female has to file the complaint. After the complaint is filed, again within 90 days, they have to conduct the inquiry. As we discussed earlier, the ICC has the powers similar to the civil court, meaning that they can invite or they can summon people as a witness, they can ask for evidence, etc., and then they can investigate the matter. Once the inquiry is completed, the ICC will provide a report of the finding to the employer within the 10 days, and the report is made available to both the parties. So why is the report made available to both the parties? Let's assume there is a case of, I'm just taking very random names. Let's say there is a girl called Shilpi, and let's say there's a case against her boss XYZ or whatever. Now, if let's say Shilpi filed a complaint with the ICC that I was sexually harassed, if the report says that yes, she is speaking the truth, but Mr. XYZ does not agree with her or thinks that this is false, then he has a right to go and appeal in the court. Or the other way around also. If the complaints committee said that no, Shilpi is lying, even then she has a right to go to the court and file a complaint. So complaint filing, after which the report will be given, this is not a final report. Not a final report as in any of the 2 parties can go ahead and challenge that in the court of law, saying that no, this is wrong. If both the parties don't do anything and they agree to whatever has happened, then the employer has to take action, as we discussed, as per their own service rules. So every company has to have its own policies. Every company has to make sure that they have their own set policies, that if a person is found guilty of this and this offense, what would we do on our part? Reduction of salary, suspension, termination, public apology, etc. There can be many provisions like that. What happens if the person has to file a complaint? Then the person can go to the court within 90 days. So all of these are 90, 90, 90. Within 90 days, you have to file the complaint. Within 90 days, they have to investigate the matter. And then if you have to file a complaint, then also you have 90 days to go ahead and file a complaint. Now, with any law, not just this one, with any law, you also have a problem of the law being misused. So with this also there is a provision that in case the complaint is false or there is false evidence given, then what happens? In that case, a complaint committee can recommend to the employer that action has to be taken against the women or the person who has made the complaint on behalf of the women. So there is a provision for tackling false complaints or false evidences as well. However, false complaint does not mean that you are not able to prove that this happened to you. Okay? False complaint doesn't mean, for example, let's say there's a female employee who says that I was asked for a sexual favor by my boss. And when the internal complaint committee says, do you have any proof? So she would say, no, I did not record it obviously, but you can ask people who were around us. And no one says that, no one basically heard that. So she was not able to prove her allegations. That does not make it a false complaint. False complaint means when there is proof that what she's saying is incorrect or she's making it up. That will be a false complaint, then action can be taken. So inability to prove or inability to give adequate proof is not equal to a false complaint. Now, this is mainly about the POSH Act of 2013, about what we have read till now. Now the question is, if the law was passed in 2013, why are we discussing it right now in 2022? The reason is that it is in the news because some people have gone to the Supreme Court challenging the guidelines given by the Bombay High Court last year. So let's see what actually happened. So what happened was last year in 2021, there was a case in the Bombay High Court regarding the POSH Act of 2013. In the Bombay High Court, there was a judge called Justice G.S. Patel. He gave certain guidelines. The guidelines mainly, and we'll discuss that in big detail, the guidelines mainly were that if there is a case of POSH, when the court gives a judgment, it should not be made public. The two parties involved, their name should not come anywhere in the media. None of the two parties should share the judgment on the social media. Basically, the identity of both the parties, not just the party who has been harassed, but even the party who is guilty, even that party's name or identity should not be revealed. The advocates, the parties who are involved in the case, none of them can share information outside in the public domain. That is what was given, that these were the guidelines that were given by the Bombay High Court judge last year. Now, it's very odd because you can say that the person who was harassed, against her or her identity should not be revealed, that is fine. But the person who is guilty or the person against whom the proceedings are going, why do you want to safeguard that person's identity? That is why petitioners or people have filed a case in the Supreme Court now against the guidelines given by the Bombay High Court judge. That is why it is in the news now. We will discuss what those guidelines are. So the guidelines mainly say that there is a blanket bar. Bar means that you cannot do something, or there is a prohibition on the parties and advocates for sharing records, including the judgment, etc., with the media. So you can't share it with the media. The judge said that no, you can't reveal the identity or you can't reveal any details of the case. As I said, the Bombay High Court guidelines were challenged in the Supreme Court about the POSH Act. Now, when this happened, the Bombay High Court judge also came under a lot of pressure. So he also made a statement. He said that the guidelines, or what we said about not revealing the identity, it was only for some cases. It was not for all the cases. Now, obviously, the judge has not clarified which cases did they mean, but they have clarified that what guidelines we said was only case specific. We did not mean that in any case you should not share the identity or you should not share the details. But let's see what the Supreme Court has to say on this matter. Now, the guidelines that were given by the Bombay High Court judge were these. First, as I said, no mention of the name of parties or their identity anywhere in the court order. So even the order of the court, which will be available to the public later on, will not have the name or identity of the people who are involved in the case. Not just this, the order, the judgment will not even be uploaded anywhere. It will be delivered in private in the chamber. Chamber means kind of an office of the judge, so not even in the open court. It will also be sealed. The entire record will be sealed and no one would be able to access that. All the hearings will be done in the chamber only or in the camera. There is no online facility. it will not be revealed in the public domain, and there will be prohibition from both the sides and parties that they cannot reveal any of the content to the media. Not just this, the witnesses also, the people who come in the case as witness, they should also sign non-disclosure agreements. So they can also not tell anyone what the case is and how the case is going on, etc. These are the Justice G.S. Patel guidelines, judge of the Bombay High Court. This was given last year in 2021, and this is what has been challenged in the court. Now, what are the arguments of the petitioner? What is it that the people are saying who went to the court? Number one, it goes against Article 19. Why? It goes against the expression of the freedom of speech and expression. It goes against the right of the person to express themselves in the media, to write themselves about what they have gone through, to share it with other people so that other people can learn from this example. It also suppresses women's voice. Why? Because see, when you are telling the women that something wrong will happen to you and we will see behind closed doors what will happen, or behind closed doors we might give punishment to someone, that means you are not encouraging women to come out in the open and share what happened with them. Because the women will now also feel that on one hand I am being harassed, on one hand I am having a bad name in the society, and on the other hand the people who are actually accused of this, the people who are guilty of this, no one knows their name. So this goes against the concept of empowering women to raise their voices. Not just this, it also goes against the principle of open court. Now, the concept of open court is, and the reason why the courts are held in the open and you can usually go in the hearings, is that open court is actually a kind of a place where you can learn a lot about different types of cases, where you can learn a lot about laws, etc., and you can take a lot of lessons from there. But when the judges resort to hearing matters in the chamber, even when they are not so sensitive matters, that goes against the principle of the open court, and the kind of impact, the kind of positive impact that these court hearings should have had on the society, because they must set an example for the society, that will not happen now. On these arguments, the petitioners have now gone to the Supreme Court. Now, whenever we talk about sexual harassment in India and the sexual harassment guidelines, there is one very prominent name that you should always remember, that is of Justice J.S. Verma. Now, Justice J.S. Verma, it's a very interesting case study. Justice J.S. Verma recommendation, the Justice J.S. Verma committee actually was formed after the unfortunate Nirbhaya case in Delhi. So in 2012, after the Nirbhaya case happened, there was a lot of demand that the people who are involved should be given the strictest of the punishment. If you remember, one of the accused was a juvenile at that time. He was just a few weeks under the age of 18 years. And at that time, the law was that if you are below the age of 18 years, the maximum punishment that you can be given for any crime was only 3 years. And that is why after 3 years, the person was released. So there was a long agitation across the country that this should not have happened, and there should have been much more stringent punishment given to that person also. As a result of which, the government of India made the Justice J.S. Verma committee to give guidelines about how to make better laws, how to prevent sexual harassment of women at workplace and otherwise as well. Now, this committee, as I said, was formed in 2012. Unfortunately, Justice J.S. Verma passed away in 2013. Now, let me tell you an interesting connection of Justice J.S. Verma. Justice J.S. Verma was actually the Chief Justice of India from 1997 for some months. Now, what is the connection? The connection is he was the Chief Justice of India at the time of the Vishakha Guidelines case. In fact, he was the one who was heading the bench of the Supreme Court in the Vishakha Guidelines case. The Vishakha Guidelines were written by him only. So he was the person who was the Chief Justice of India at that time. He was the one who was the head of the Supreme Court bench when the Vishakha judgment was being heard in 1997. And in 2012, 15 years later, he was the one again who was asked to make a committee, and he had to give a report on how to make the laws about sexual harassment in India much more stricter. I still remember when the J.S. Verma committee was formed. In fact, they gave a big ad in the newspaper with an email ID saying that if you common people have any suggestions about how to improve the sexual harassment laws in India, you should write an email to them. So anyway, the J.S. Verma committee gave their report, and the main pointers of the J.S. Verma committee was, number one, they said that rather than having an internal complaint committee, we should have a kind of a tribunal. They said that internal complaint committee at that point of time might not have experts. So if you really want to have this matter investigated, you should have experts and maybe make a tribunal for that matter, where we would have experts from that field. We might also have participation from judges, etc. Also, if you are confused that POSH Act came into being in 2013, then why was this committee in 2012 and why were they saying about the internal complaint committee? If you remember, I told you the POSH Act came into being in 2013, but the bill process started in 2010. So everyone knew what is the content of the law. The committee gave its report thinking that after the report, the bill will be changed, but the bill did not really incorporate those changes. So first they said, rather than internal complaint committee, let's have a employment tribunal, external body where people can go and file complaints. Second, these committees or these tribunals should have the power to form their own procedure. So they should not be given one single procedure to hear cases. They should be allowed to set up their own procedures, and they should be able to conduct their own inquiry in the manner that they seem fit. The scope of the act should be expanded. How? They said even the domestic workers should be included in this act. Now, if you see the provisions of the act, it does not really make a mention of the domestic workers, which is unfortunate because a lot of time the domestic workers also have faced this issue of sexual harassment. So their suggestion was that domestic workers also should be included, and any unwelcome behavior from anyone should be seen in the scope of sexual harassment. Another important point that this committee recommended was that the responsibility of taking action in this regard, the responsibility of doing justice should be on the employer. The employer should be the one who should be given the responsibility that you should have stringent guidelines. You should create such an atmosphere at your workplace that number one, this situation does not arise. And if this situation does arise, you should give enough confidence and enough backing to your female employees that they are not really thinking twice before coming and registering a complaint. It is, in short, the responsibility of the employer to make sure that the female employees at the workplace are happy, comfortable, and if something wrong happens to them, they should not be thinking twice before filing a complaint. Now, apart from the law, we also have the entire Ministry of Women and Child Development in India that is specially given the responsibility to ensure that whenever women have a problem, it may be sexual harassment, it may be something else, they have a place where they can go and file a complaint. Ministry of Women and Child Development, in fact, in the past has given many guidelines to clarify what is sexual harassment. They have even taken many initiatives such as the She Box, where women can go and file anonymous complaints, etc. It's a portal run by this ministry where you can go and file anonymous complaints. So they are taking certain action on their own behalf. What is it? The ministry recently published a handbook which talked about sexual harassment of women at workplace, and they gave detailed instances of what exactly can be called sexual harassment. They said that sexually suggestive remarks, display of sexist or offensive pictures, intimidation, threats, unwelcome social invitations, unwelcome sexual advances, all of these are within the purview of sexual harassment at workplace. The handbook also says, that is released by the ministry, that unwelcome behavior is experienced when the victim feels bad or powerless. This is illegal, demeaning, invading, and it is power-based. So the committee in itself is trying, the ministry in itself is trying to ensure that women always have a place where they feel heard, they always have a place where they can go and register their complaints if they are not being heard at their workplace. At the international level also, not just India, at the international level also, at the UN specifically, there is a convention called Convention on the Elimination of All Forms of Discrimination Against Women. Now, it is unfortunate but true that this is not really a problem that is specific to India. in almost every country across the world, including the developed nations, the least developing nations, or the developing nations, in almost every country across the world, we have seen problems of sexual harassment for women, specifically at workplace, inside the homes, and in the general society. It's such a big matter that even the UN has passed a resolution to ensure that women are protected, and there are stringent laws passed in almost every country. This convention was implemented in 1979 and is described as International Bill of Rights for Women. As you know, Bill of Rights is basically a phrase that is used for fundamental rights related concept in the US. This convention says that discrimination against women is any distinction, exclusion, or restriction that is made on the basis of sex, which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women. Now, India is a signatory to it, first. The second important part is any country that ratifies this convention. Ratify means India has signed it, that is one part. Ratification means after signing it, your country's national parliament also has to pass it, that is ratification. So India did ratify it in 1994. So the law says any country that has ratified it, it becomes legally binding on those countries that now you have to make laws for protection of women and to ensure that there is no discrimination that women have to face. So that is why this convention is important. Now just a side note, you see whenever the government or any government agency, any government department publishes an employment related ad, it can be the UPSC notification also, you would see that in those ads there is a line that is mentioned that we encourage women to apply in large numbers because we provide equal opportunity irrespective of your gender. That doesn't really mean that they are providing any reservation for women, but in almost all the employment related ads of government or even in private companies now, you would see that they use this line that we encourage the women candidates to apply because we give equal opportunities to all the genders and we do not discriminate. For all the laws that we have passed, for all the initiatives that we have taken, what exactly is the present situation right now? Now, although we have numbers, official numbers from the government, but remember one thing, sexual harassment specifically is one thing where most of the cases will never get reported. I'll give you a very small example. Let's assume you're walking on the road and someone snatches your mobile and goes away. When you go home or when you talk to your friends, there is a good chance that you will not share it with them. Why? Because you think it will make you feel weak. People will think, oh, this is such a weak person, he could not even protect his mobile. So mostly you don't want to share an instance where you are looked upon as a weak person or as someone who could not protect himself or who could not really protect his or her property. Now, do you really think a person who has been sexually harassed, would the person be comfortable to share what happened with her? Not really. And that is why a majority of the case of sexual harassment, not just in India, even in the most developed nations, never get reported. That is why the society as a whole has a responsibility of not seeing the people who have been harassed as the victims. The society has a responsibility of encouraging them, empowering them, and making them feel as much a part of the society as we are. To ensure that the people who are guilty, they should be punished, they should be the ones who will be feeling guilty. Now, the official numbers are, as per the Ministry of Women and Child Development, between 2015 and 2017, a total of 1631 cases were registered under the POSH Act. There are some states which have seen higher number of cases registered. UP has topped, then there is Delhi, and then there are other states. Even the Indian National Bar Association, in a survey that they conducted, said that sexual harassment is widespread in different job sectors across the country. So it's a problem that is widespread, and do keep in mind that these are just official numbers. These are numbers where women have dared to come in the front and register their complaint. The real number can be many-fold, and that is what the government has to keep in mind while making policies. And as a society also, we have to make sure that we create a conducive environment for these people to come out and register their complaints. This is everything you needed to know about the POSH Act of 2013. I hope it was helpful, and I hope that the topic that we discussed today is clear for you in every aspect. Thank you so much for watching the video. Bye. Good night.